All righty. Looks like we're live.
Yes,
Abogado,
we
how
are.
are you?
Good, good. How are you,
Hey,
Brenda?
I'm good. I'm good. Happy Tuesday, everybody that's waiting on this Facebook Live. This is our Tuesday Forward Together, our English version of Palante Mi Gente. Brenda Bueno from Oxígeno Radio. If you don't know me, your parents probably do, and if you guys don't know Vasquez and Servi, you need to. So, Attorney Thad Servi with us today, and of course. A lot has been happening, Abogado Thad. I mean, there's a lot coming down the pipeline, some things that are concerning, some things that could change people's lives. I mean, we do have questions, we do have a lot of participation, but what is going on? What is the new thing? I mean, what do we have to discuss? And anybody that's actually watching this video, please share. Please compartan este live, all of you that speak Spanish. Of course, this is our English podcast for today. So go ahead, Abogado, where do we start?
Okay, so we've got a negative decision from the Board of Immigration Appeals regarding advanced parole. The name of the case is matter of Milagro Delcarmen-Lara, and it was just decided last week. But this is what it affects. It affects advanced parole. So to step back on this, if someone's in the United States with unlawful presence, okay, they have a bar. They have a bar to admissibility. It's inadmissibility. Sometimes we call it. But that bar does not kick in until someone leaves the United States. Okay, so the classic example is going to be someone with TPS or DACA is here in the United States with unlawful presence before they receive DACA or TPS. Okay, those are not lawful statuses. It stops you from accruing unlawful presence. Okay, temporary protected status can be considered a status, but it does not allow people to adjust status inside the United States if they enter the United States without inspection. So a person, oftentimes a kid, if it's DACA, they enter the United States without any sort of inspection, or they enter with inspection, with a visa typically, but they overstay and they start accumulating unlawful presence. Okay, unlawful presence is going to start as of January 1st, excuse me, April 1st of 1997, okay? And when you are age 18 or more, okay? So they leave the United States and they're traveling with advanced parole. The typical thing that we would do in the past is someone with TPS or DACA, we get the advanced parole, they leave with the advanced parole. And under an older case, matter of Arabelli, that departure was not considered a departure for purposes of triggering this bar. This new case, matter of Delcarmen-Lara, it is now an unlawful, it triggers that bar. And so what happens is that person, once they come back into the United States, they now have an entry. It's an inspection with parole, but they've triggered the bar. Here's the important thing about this. Now that person can apply for adjustment of status still, but they need to apply for a waiver for unlawful presence. And to be successful with that, the first thing you need to do is show that you have a lawful permanent resident or United States citizen parent or spouse. Next, you have to show extreme hardship to them. So I think we're still going to win a lot of cases so long as someone has that qualifying relative, that parent or spouse who's a lawful permanent resident or citizen, and we're going to win those cases. We win waivers regularly, but under the right circumstances. But the trick to this is that qualifying relative. And so if this is a person who does not have a spouse, we're relying on a parent, and there's still a large portion of the population that does not have a parent who's a lawful permanent resident or citizen. Mm-hmm. So those people are stuck. The other people are going to go forward. We're going to apply for the adjustment of status. And there's a lot of nuances to this. So I just want to say that each case has to be evaluated independently before we apply for advanced parole and apply for the waiver and adjustment of status when someone comes back, because in certain situations, maybe the person never had unlawful presence. For example, with these kids with DACA, they've had DACA since age 16. We have to line up those work permits and see if there's any gaps there, because with those gaps, that's going to show as if there's unlawful presence. We're moving forward. We're going to keep pushing these cases. The thing I don't like about this case, specifically the facts on this, is this person had an order of removal previously. And so the attorney who represented them submitted a motion to the immigration court to reopen that order simply based upon a path forward now.
Wow.
Now, what I would have done, and what I've done many times, more times than I can remember, I would have just had that person come back in. We would have applied for adjustment of status because they didn't need that. They had a case with them as an arriving alien. The jurisdiction was proper with USCIS, and we've submitted so many cases and secured lawful permanent resident status for people in this exact situation. Okay. That's one of the things that I'm seeing here. So sometimes, the government would insist on an I-212, which is an advanced permission to reapply for admission after an order, but I never had to do that in the past. I have many people who are lawful permanent residents and now even citizens. Well, we had an attorney in Miami that did something different, and now this case came to light, and it's got a spotlight on it from the Board of Immigration Appeals. There's still some attorneys who are saying, oh, just file an I-212 now, some very well-known attorneys. The law is kind of on both sides with this.
Okay.
But with this case, I'm afraid that the next hammer that's going to drop is going to be, you need it's like you can't do this. You need a motion to reopen also.
Oh, boy.
So, it just highlights the importance of having a very good attorney on your
Sure.
case before you take some sort of action like this. And I wish the client was mine instead of whoever represented them down in Miami.
Right. Now, what's concerning Attorney Thad is that because of how the immigration environment has been, with this particular administration, a lot of especially the people that have, DACA. So DACA recipients are like, man, I should have requested an advanced parole before. So now I got to kind of do it, with that sense of urgency. So a lot of them are desperate to leave, go to their home country for, some kind of humanitarian family reason, emergency.
Right.
But right now, unless they know exactly, do I have unlawful presence? This is really just for those that, because another thing we were speaking about actually this morning on the Spanish show is that so many DACA recipients, Attorney Thad, they were 19, 20, 21 when DACA came around, and they're like, oh, I qualify for that because I came in before I was, 16?
Yes.
And I have a high school diploma. I meet the criteria, but they were already over the age of 18. So let's just say that a young person back when he was 20, 22, he decides to do DACA after the fact, which he could. He has unlawful presence accrued because after he turned 18. So a lot of those young people are now they're in their 30s, maybe even later. They want to do the advanced parole to get that legal or get the entry with the inspection so that they can adjust with a spouse. But then they're like, wait a minute, should I not? How do they know? Like, how can they be absolutely certain that, number one, what if we can touch base a little bit? What is advanced parole really good for? Like leaving, with permission from the government. What is it for, number one? And how do I know if I have undocumented presence accrued? Because that's who's at risk.
Sure. So, should you apply for advanced parole? Let me step back on this. This is an important thing right here first. If you've already executed your advanced parole and you came in before last week, we're good to apply for adjustment of status.
Yeah.
You don't need the waiver. Okay.
Yeah.
Everyone, I hope everyone's got that. In that situation, you're golden. But if you're thinking about getting the advanced parole now, or your advanced parole is pending and you want to leave and come back, either one of those, it's the situation. Now we're dealing with the new law matter of Delcarmen-Lara. So advanced parole is basically this. You have TPS, or I should say had TPS for most people now, or you have DACA and you need to visit one of your relatives who's sick and ailing. The closer the relative, the better to get this thing approved. It's also available for international studies and international work. Maybe there's a conference abroad or something like that you need to attend. So a lot of people would, honestly, they're going to look at this and go, my goodness, yes, I want to visit my aunt. I haven't seen her in forever and she's sick. But
Right.
one of the reasons to travel is to go out and come back in so that you can adjust status based upon your U.S. citizen spouse or kid. That's it in a nutshell. Um, and so that's the impetus. That's the reason to travel and come back in, those two things. And if you did that, you're still good. And if you want to do that, now you have to file for a waiver with your adjustment of status case, and you have to show extreme hardship to that qualifying relative.
Right.
Now, if it's a spouse, your case is almost always going to be approved if it's properly presented, especially if you have a spouse and you have some minor children that you're taking care of, because without the approval, you're basically looking at a situation where perhaps that person's going to be a single parent. Okay, we can hit the level of extreme hardship with that. But if you have a parent who's a lawful permanent resident or a citizen, and they're not living with you, my case suddenly gets a lot more difficult to prove.
Right.
Okay, that's the one that concerns me, and the people who just simply have no qualifying relative whatsoever.
Right. So of course now, let's just say that they do decide to move forward because they do, want to take that step. How can someone know if they have? Maybe it's been so long, they came in when they were tiny children. Like, how do I know if I have unlawful presence somewhere?
Okay, so we're going to start at age 18 in this scenario. Almost everyone has been here since April 1st of 1997, so we'll just say age 18. Well, since age 18, did you have DACA? Okay, now, when you had DACA, did you renew it on time, or do you have gaps in your work permits, in your approvals? Specifically your approvals, which corresponds with the work permits. There's very few people who don't get the work permits with their DACA applications. But you're going to line these things up right next to each other, one above the other. You're going to look for any gaps there. Sometimes people lose those documents. We can try and get them from the USCIS through FOIA. That's another story, because it's harder to get documents these days through FOIA, but I'm still getting them. It's just like pulling teeth. Okay. But we want to line up all those things, and we're going to look at that and see what the unlawful presence is after age 18. Hopefully it's not great. Now, something that happened with DACA earlier this year, actually late last year, from about October until about late February, early March of this year, there's a whole lot of DACA applications that are just sitting there unadjudicated with USCIS. It's bizarre. It's not what our government is supposed to be doing, but they're just sitting there. And so there's lawsuits to sue USCIS. And we just submitted one a couple weeks ago. It's called a writ of mandamus to get them to push a DACA case. They have to adjudicate it, and it's a clean case. So, of course, we're getting the federal government to say, USCIS, adjudicate this case. They can't tell them to approve it, but there's no reason to deny this case either. And that's an option for people that's a bit apart from this, but that's what we do. That's how we figure out if there's unlawful presence.
Well, that's good. I mean, so at the end of the day, it sounded, when we first heard this last week, which these things just happen sometimes arbitrarily. You just never know what someone's thinking when they decide to make a change like this. Now, it sounded like you said, like the hammer came down, like just doors have closed, and it sounded very tragic, very horrible. But if it's done correctly, there just has to be an extra step when you do this waiver. Or is it the same 601? Because a lot of people are used to hearing the 601, 601A. So a waiver is an extra step in order to say, okay, yes, maybe I did accrue some undocumented presence, but it wasn't risky for me before. Because a lot of people that they'll say, well, whatever happened before, I've already got my DACA, I've already got TPS, and they feel protected, like nothing that happened prior to that is relevant. But this makes that relevant now, even if you've had DACA for 10, 15, 20 years, TPS that people have had for 20 something years. So they have to be really careful. But thankfully, it's difficult, but it's not like the end of the world. It's not life or death. It's just adding an extra step with the waiver, correct?
Yes, it is. But remember this, you have to have the qualifying relative to apply for the waiver. And if you have a situation where it's your parent that's a qualifying relative, and they're living with one of your other siblings in another house, or that parent is living on their own because they're still young enough and healthy enough to work, we don't have a strong waiver case. We're looking for something where the parents are living with you because they're elderly, they have some health issues, they're no longer working, they're past the age where they're going to work anymore, and they need someone to keep an eye on them. We can almost always win those cases. They're a bit more difficult than the spousal cases. But that's one of the problems that I'm seeing on this.
Oh, wow. So But still, the best, I guess, the best point that we can make now is that before you do step foot outside of the US, please find out. This morning they were asking on the Spanish show, well, what if you guys are not my attorneys, Vasquez and Servi? Can you guys check that out for me? Can I get this done kind of in an urgent fashion? They can, of course, get a consultation, correct?
Absolutely, absolutely. So, I see a lot of people that renew DACA on their own. They go to notaries. Please don't go to notaries. Or they go to another attorney, whatever it is. It's like we have a lot of excellent attorneys here. We have 6 excellent attorneys here, and we have open lines of communication through a secure portal. Set up the appointment, bring in all your documents. We'll line them up right there in the first appointment, and we'll see what you got.
Is there any way to fight this? I mean, is there any way that this could be reversed once again? This crazy decision that was made on a Thursday, in the middle of summer. Is there any way to do anything for that?
Well, of course, this decision can be appealed. I see the other side's argument for saying that you're going to trigger the unlawful presence when you leave, even with advanced parole. Of course, I'm not going to argue that for my clients. Let's be clear about that. Right. But I also think that what happens, or what happened in the past and what's going to happen again, is we get a new president, we get a new attorney general. And I think that what's going to happen this time around when we get a new president, I don't think it's going to be a Republican, but please, everyone get out and vote. Please. We're going to get a lot of new judges on the Board of Immigration Appeals, because right now with this Board of Immigration Appeals and with these immigration judges that have been appointed, they're political appointees. They're Republican leaning, and we're not getting a fair shake. So this, Arabelli, let me see here. That was a case from 12 years ago, 14 years ago. Okay, 14 years of precedent that we had, and all of a sudden they're pulling the rugs out from underneath our clients and their families. So I think we're going to get a new attorney general, and what happens with the new attorney general, he'll be like, give the case to me directly. I'm going to write the decision on it, and that holds just like the Board of Immigration Appeals wrote it. But we're a good 2.5 years from that happening, probably 3 years.
And thankfully, none of this is retroactive. So those people with DACA or TPS, if they left the country, did their advanced parole, they came back before August the 13th of this year, they're fine. They're not going to say, oh, you left, 3 years ago, you went to El Salvador, you went to Mexico 3 years ago, you're out of the game.
That is true. That is clear on this decision.
Good.
That is clear.
Besides, the exit and reentry was made before it was even brought up as a possible risk, so they can't be faulted for that.
That's what the decision is saying. Okay, and this is an interesting. I'm thankful that portion of the decision exists, but this is a clarification of the law. It's not a change in the law, and so when you see clarifications in the law, a lot of times they'll say, no, this is retroactive. We're just clarifying what happened. It's not like a criminal case where someone accepted a guilty plea because they didn't think there was consequences. This is just something where it's, they executed the advanced parole. But knock on wood, we don't get another negative decision on this from one of the federal courts if someone chooses to appeal it. And I don't think that we're going to see anyone appeal this. I think it's going to be just wait for a new administration.
Wow, that's a long time still. It feels like forever. So in analyzing this just from a general perspective, if someone says, well, I've done my paperwork, I have my advanced parole. Now, the one of the things that's kind of tricky about this, is that let's just say that someone says, well, I'm still going to go ahead and do that because I feel like, it's better to do it maybe in 2 years. Now, you won't really know that there's a problem, because here's the thing. A lot of people will say, well, I got my advanced parole. It was approved. I went to Mexico to see my grandmother who's 98 years old. I was able to come back. I came back and they approved. I'm back in the U.S. and they're really not going to know if there was a problem until they do adjustment of status. That's when it hits you, right? It's not like, oh, you left and at the border or at the, at the airport, they're going to stop you. You can find out later if that was detrimental, right? That's the problem.
Well, yes. So let's just say if you have the approved advanced parole, you're going to be able to leave and come back. You pay your $1,000 extra penalty, I guess you would call it. And they call it a fee, but Trump instituted this several months into his administration, where now you have to pay an extra $1,000. But simply put, you should be able to come back without a problem. Okay. And if you have a U.S. citizen wife, we should be able to win a waiver for you. We win these cases regularly.
Got it. Got it. So we'd like to just remind everybody, if you guys are watching this, you guys can, thank you for Faustino. He loves the law firm. Thank you. Today's his birthday, by the way. Faustino, happy birthday. But of course, you guys can be as interactive as you'd like. Send us questions. We'll be here a few more minutes. But interesting also, we had a question come through this week for this particular episode. What about these issues with blended families, Dad? Let's just say a U.S. citizen child says, okay, I'm 22, I'm ready to help my parents, but they've got this blended issue. We have one that he said his mother came in with a tourist visa back like in 2001 or so. Dad came in without inspection illegally. And so he's like, well, these are my parents. Is the process different? What do I have to do for each parent if I want to go ahead and submit a petition? It's going to be different because mom came in with a visa and dad came in without one.
Well, what it sounds like in this situation, without verifying all the paperwork on this, mom came in with inspection and was admitted with a visa. So even though she overstayed, we can apply for a family petition and adjustment of status and a work permit, and mom's going to adjust her status inside the United States. Okay, now dad's a little bit more difficult. They can do the petition for dad immediately, and we'll talk about doing it immediately versus waiting for mom to become a resident. But dad would have to do the family petition, and because he entered without inspection, he's almost certainly going to have to leave the country and process his case in the consulate. We would submit an application for a provisional waiver before he leaves, and we're going to wait for its approval. And he's going to leave with that in hand, and he's going to be outside of the country for about a week and a half. Now, his wife, the mama, she has to become a resident before we can apply for the waiver. Because remember, he needs a qualifying relative. Unless one of the parents is a resident or citizen, we're going to have to wait. I will point this out also, that even though we can apply for dad and he can stay here and wait for the approval of the provisional waiver, well, it doesn't give him protection against removal. Okay, so when we submit the family petition, if the government sets an appointment for him, he could be detained. Okay, it hasn't happened to my clients because I just am telling them, the beneficiary, don't show up for the appointment. It's not required. This is your son. It's not required for these types of cases. It's your son's case, which is your U.S. citizen daughter's case. I'll go to the interview with them, and if they ask where you were, I'll say that you chose not to be there.
Oh, so it's pretty simple then.
Yeah, it's a little bit nerve-wracking for,
I'm sure.
for the clients, but yeah. We know how to proceed with these things.
I mean, and I'm just happy that people are looking for the information, and because of so much content that there is that they just don't know where it's coming from. People are just making, weird decisions left and right. They're using weak evidence and just weak processes. I mean, I had somebody asked today, they said, well, what if you work at a job and they don't pay you? And so you end up leaving because they owe you money. Can I get a T visa? And it's like, a T visa because you worked somewhere and they didn't pay you. It's really not, that's not what that was designed for,
No, I mean, so the T visa, watch out for that. That's one of the big scams that went on in Lozano law firm out in Washington. Is, she had to abandon her license because of that, forfeit it. But the T visa, the typical situation for is that you were brought here on account of one of two things. It's human trafficking for sex purposes. That's the classic case. But you're here on account of fraudulent work offer. You were induced to coming here by fraud. And so you'll see that happen sometimes with the agricultural workers, where they process their H2 visa, H2A or H2B. They show up at the farm, they show up at the whatever company it is to work temporarily, but they're abused, they're given improper housing, they're not paid according to the contract. So in those situations, yes, the T visa is very appropriate also, but not like, oh, I showed up here 20 years ago and my last job, they didn't pay me. That's not going to fly.
Yeah.
It's not going to fly, guys.
That's important for people to know that, because sometimes it's the last straw that they pull for, especially when there's so much content telling you can do it. You got a kid that yelled at you one day, we can get you the
VAWA,
VAWA.
yeah.
God, man, it's horrible what's happening. Yeah.
I'm also going to point out this, Brenda, that watch out if you're hearing on social media about attorneys that are sounding like the oracle on this situation with the advanced parole. That we just file an I-212 and that's it. If you had a previous order, it's not that simple. Okay, it's not that clear, and I'm not going to tell you that that's all you have to do and everything's going to be fine, because I can see the other side of the argument too, and so my case is, for the I-212 is probably that it's going to win, but it's not a definite thing. It is not.
And those that are coming on a little bit later, can you go over when we say I-212, what exactly is that for?
Okay, so if you had a previous order of removal or deportation, you execute the advanced parole, you come back in, and then with your adjustment of status case, you're not just going to submit the waiver for the unlawful presence. It's going to be the I-212, an application for advanced permission to reapply for permission. That's a mouthful. But it's basically an application to avoid the grounds of inadmissibility for the previous order.
Okay.
And you submit that with the adjustment of status. And frankly, even with the previous case, matter of Arabelli, I was able to avoid even submitting that I-212. Okay.
Uh-huh.
And it worked repeatedly.
Well, that's good. I mean, at the end of the day, when you know what you're doing, that's why when people go to these notaries, or they'll go to, a tax preparer that happens to be bilingual, and the tax preparer says, well, I did what I could, and I kind of understand what you just did, but when there's issues, they can't represent you. I had someone ask me the other day, I used a tax person for, I think, renewing their work permit, and they said, can that person go to court with me? I said, no, unless you're going to tax court, right? I mean,
that is true, and maybe not even then. There's a lot of
maybe not
people
even
out there that
Yeah.
Don't have that certification to go to tax court. But this is much more than just filling out names and dates of birth, okay, and countries of origin. There's a lot more to it than that. So the law is pretty thick on this. This is one of the although it is a form-based practice, just like taxes are. This is a complicated issue, and our clients typically don't have these clean cases where they came in as students on F1s. They're still in F1s, and they meet their sweetheart who becomes their U.S. citizen spouse and applies. It's much more difficult than that for the vast majority of our clients. Sure. Because they have issues where they've overstayed, where they've came in unlawfully, and they have DACA. I mean, we run the gamut on that.
Sure. And I want to point out something from our last, from our very first, which was back 2 weeks ago. I mean, there are comments, and I think that I just want to be clear, people that are going to say, well, leave and come back legally, do it the right way. We're not going to entertain these kind of comments because that's old, it's tired. But what I want people to know is that even because that's just that seems to be the default, like, well, if they do it the right way, well, there's people that doing it the right way, and they're still not getting results. And the government is making it almost impossible. There's people doing things the right way. So again, we're not going to entertain those comments, but it's important for people to say, well, why don't they just do it right? Why don't they just come in and knock on the door? They're doing it the right way, and they're still not getting, the results that they deserve.
Well, exactly. But I'll also say this, that yes, I get it that you're not supposed to come to the United States without documents, but if they're here and they've worked forever and they've got kids and a spouse, I don't think it's right for the government to put the cart before the horse and say, get out. No, it's going to hurt these people too bad. You're not just hurting someone who came into the United States unlawfully. You're hurting their wife and their kids and their employers and the community. And so we have to find a way to correct this without destroying families and putting those families on welfare.
We do have questions that came in from earlier. It says, a little bit, different topic. It says, can you please ask the attorney later, what's going to happen? I had my hearing with immigration on August the 11th, but it was canceled just out of nowhere. I don't know when the next date will be. What do you think could happen? Now, I don't have any history on what kind of hearing it was. If it was, something with asylum, with something, maybe a work permit. I don't know what it was, but what does it sound like when someone's like, I'm nervous to go to my court date or my hearing date, and all of a sudden it was canceled? Is that normal?
It can happen. It's not the the typical thing, but it's not that uncommon either. So what I can say about this is depending upon the type of case. If you're in removal proceedings, go to the EOIR website and look at case status and enter your alien number to find your new court date. Okay, that's not 100%, but you can also, you have to update the court with your address so that you do get the notice of the new court date. If it's with USCIS, because it's an asylum case or adjustment of status, naturalization, etc., you have to wait for your new appointment to be set with USCIS. So your case is still pending, whatever it is.
We have a question, interesting. It says, with what the topic that we are touching on with as far as the advanced parole and, the undocumented presence, they're kind of connecting it. It says, with what's been decided last week, does this affect those people that have children in the Army? Does it affect like military parole in place?
No,
or no?
it does not. No, it does not. Totally different. So
Got it.
the military parole in place still exists. It's untouched. And there's a difference with that. So if someone's here unlawfully, okay, that doesn't mean they overstayed their visa. It means that they entered without inspection. They're eligible for parole in place. And that parole in place does not trigger anything, and because they never left the United States. Okay. That's the big difference. So
Good.
We're working on those cases. We're getting approvals for those cases.
Wow. And our last question for today, it says, if someone was not able to present their medical exams because they weren't ready on time by the date that they were given, do they get another, what's the repercussions? ¿Se cancela o tiene alguna repercusión? So does your case just kind of fall apart? Do they cancel? Do you lose your place in line? What happens if your medical exams were not ready by the date that they were requested?
Okay, so that sounds like there was a request for evidence on a pending adjustment of status case. And so if you don't meet that deadline, the USCIS can and probably will just deny your case. You're going to have to reapply, and you better do it quick. And I would also suggest, if that does happen, that your case is denied, that you submit a motion to reconsider showing that you have the medical exam, but you better refile at the same time. Because what we're trying to do with that motion to reconsider is avoid this person being placed in removal proceedings. Okay. Because the case just gets much more expensive for us to try a case in court, and it takes longer. So, I will also say this, that there's also been a recent publication from USCIS saying that they're not going to ask for things that are absolutely required. Like if you don't include the birth certificate, the marriage certificate, the medical exam, or, for example, an affidavit of support, they're just going to deny the case. They're not going to ask for it. So it's very important to have somebody who really knows what they're doing. And
that was last week, wasn't it? Or 2 weeks ago?
It was about 2 weeks ago.
Oh, man. Yeah, so remind us about that. So it's just like, okay, you didn't send it. We're not going to say, oh, you forgot. So they're just going to say, now, do all denials automatically lead to deportation proceedings?
I can't say it's going to be automatic, but it seems to be the normal situation these days.
Yeah.
And so that's a rather vague memo. They don't say exactly what it is. It's like, if you can imagine, some things are just cut and dry. You need to have your medical exam submitted with your adjustment of status case, okay? And so if it's not submitted before your case is denied, you better submit it to try and fend off that denial and being placed in removal proceedings. But there's other things on this, such as, well, is there enough proof that this is a valid marriage? Or if it's a waiver case, is there enough proof of extreme hardship to the qualifying relative? And that's what I really don't like about this memo. I get that you have to submit the medical exam and the required documents. But when it comes to these discretionary things, like, is there enough evidence here of a valid marriage? Well, that's part of the reason they have an interview too.
Right.
So it's hard to say what they're going to do with this memo, but it looks to me like we're going to see some officers using it as the floodgates of abuse.
Right. The end all right there.
Yeah.
Now, that's why, touching back on what you said, don't just go to anybody. I mean, I know that just over the years, Vasquez and Servi has always been so, and some, that we've had people that say, oh, but they're so picky and they don't want to do this and they don't want to, like, if I have a friend, which I do have to say this, people say, well, I've got a friend that's willing to marry me to give me status. Well, you guys do things the right way all the time, and you guys are meticulous. I don't think it's picky. I think it's meticulous because you guys do things Right. And that's important because you guys, I'm sure, have a checklist of things that are needed according to what process or what status you're trying to achieve. And if it's marriage, if it's, doc, if it's whatever. So people sometimes get frustrated. I thought it was going to be easier, but you want things done right. That's why you just don't go to some bilingual person that sells insurance.
Yes, yes. It's not just a checklist. It's not just a laundry list. Some of these things, you're looking at a piece of evidence, it weighs in your favor. There's things that are going to weigh against you. And so we're going to try and build it with an accumulation of evidence that's a good stone's throw beyond what we need. We don't want to win. We don't want to win by an inch. We don't want to cut it that close.
Right.
And we don't want to go overboard with this stuff either. So we want to win by a very good, comfortable margin.
And the question that came in now is specifically related to the topic that you just mentioned, with the request for like the evidence. If they don't ask for something that you forgot and they do like the denial, how do you recover from that?
You're probably going to have to resubmit.
Everything?
You're going to have to resubmit, or you're going to be in removal proceedings. It's hard to say. And I mean, and we try and save these cases. I'm not saying that we can't make an error, but we're very careful. And we get a lot of work that we have to fix because something went wrong. And it can be for a variety of reasons. And, it could be sometimes people go to the wrong person that fills out some crazy story for asylum or something like that.
Yeah.
And we've got to deal with that, and we deal with it.
Of course, I'm sure.
We clean things up here.
Well, before we wrap up, I mean, if anybody has any questions, go ahead and type them into the conversation now. I mean, Attorney Thad, at the end of the day, things change literally from one moment to the next. You guys are always on top of, what's going on. Even you guys were gone for a week and still you guys were on top of everything, ready to give us content yesterday, today, and the rest of this week. There's still a lot to share. But I mean, really, how do we sum up what's going on right now? Things change at any given moment. There's always a way to, get good information. Of course, the number across your screen, 678-308-0018. Consultations can be over the phone, over video, no matter where you're at in the world or the United States. So how do we summarize? Like today, what are we looking at? We're looking at the possibility of just taking that extra step. And before you leave the country, please consult with an attorney. I mean, what else?
Absolutely.
Can we tell
For the advanced parole, talk to us before you go. I mean, I don't know. Talk to us before you even apply for the advanced parole. Okay. It's, they're harder to get these cases approved also. I want to say that. I want to give a quick pitch for my show in Spanish on Thursday.
Yeah.
Thursday morning. It's going to be about the CBP Home app.
Oh, yeah.
And the $2,600 stipend. And we're looking into that because a lot of people just say, it's like, I look at it and go, if you use the app, there's a good chance that you're not going to have any problems, okay, when you're leaving the United States. But there's also a $2,600 stipend that can help you out with your costs as you're constantly processing, or if you have to go back, gives you a little bit of a basis.
So CBP1, now it's home because it was CBP1. So if you came in to the U.S. seeking some type of protection, and so CBP1 was your little gateway, are they tracking you? I've heard that. Did they track you with that? Because it's on your phone. What do they do with that? And now they expect you to use it to leave?
Yes. It's like, I think that they can track you, but, the advantage can be, well, I have to leave anyway.
Right.
So I want to be able to go to the airport and not get detained. And so I have not heard of anyone being detained when they go to the airport and they're using CBP Home.
Okay.
I said CBP1,
Yeah,
CBP Home.
Wow.
And so you can always imagine that there's going to be a glitch in the system, but I don't want to invent those problems. I've not heard of that happening, but theoretically anything could happen, but it looks like it's pretty clear. But I don't think anyone should do that without consulting an attorney first.
Can we sum up a little bit also, I guess, pretty much a description on, and this is huge because I hear it every single day in my afternoon job at another firm. I was not deported. I signed a voluntary departure. I mean, people think that because they signed and they bought their own ticket or their family bought their ticket, that's not going to affect them. But can you please explain the difference between, yes, they put me on a plane in shackles and I was taken away, or no, my family bought a ticket, I was not deported, I left voluntarily?
Okay, so there's various types of voluntary departure, but the most famous one is going to be that you're in immigration proceedings. You know you're not going to win your case, the cancellation of removal or asylum, so you accept a voluntary departure, an order of voluntary departure, and yes, you sign for it. Someone buys a ticket for you to go back home, whether you are still detained at one of the detention centers or you're on the street. Okay, now just because you leave does not mean that there aren't consequences here, because remember that you were here and you were probably here without unlawful presence. It's 99.9% of the time. So if you come back without inspection, because of that unlawful presence, you're going to have a permanent bar to securing immigration benefits. You're going to have to leave and be physically outside of the United States for 10 years. And then you're going to have to apply with the I-212 that I mentioned earlier.
Sure, sure. Attorney Thad, there's just so much going on. We love this new space, the English language. Please share it, even when we're done. Share it as many times as you think someone could benefit from it. Sons, daughters, spouses, fiancés, they all kind of want to know what's going on. So there's plenty. I mean, we've got content that we can work off for probably for here to next year, and we'll keep adding more to it. And please, if you have suggestions on topics, please write us, send messages to the Vasquez and Servi Facebook page. Of
Yes.
course, we'll be here, every Tuesday in the evening, whenever our schedules allow. But hey, that's what this is for. Again, there's just so much confusion, Attorney Thad, and so much content that you just don't know really what's behind it. And you guys have been, what, 30 years now doing
30
immigration
years,
law?
yes.
Can't beat it.
29 for me, 30 for Barbara.
Nice. 678-303-0018. Please take this number down. Watch this video several more times, because it's like a movie. You watch it once, you kind of miss some things, and every time you watch it, you hear something new. So we want to thank everybody that's been tuning in. Keep sharing. Por favor, compartan all these, Spanish listeners that like to kind of refresh their English a little bit. But thank you, everyone with DACA, with TPS, people that are, that are in relationships, people that have blended their family with immigrants. Hey, I mean, it's richness, it's culture, and I think we're all here to do things the right way, because we all want to do things the right way. And if you want to do things the right way, Vasquez and Servi is probably your best bet. 678-303-0018. I'm Brenda, Attorney Thad. We'll see you. Well, we'll speak on Thursday, but then we'll see you again next Tuesday.
Absolutely.
Thank you, guys.
Thanks, everybody.
Share the video. Have a good evening.